This is the India Development Debate right here on ET Now. I'm Supriya Shrinate, and straight on to the big story of the day. The wait for decriminalisation of politics, many believe, is only getting longer. The Supreme Court today ruled that it cannot cross the Lakshman Rekha and will not bar criminals from contesting elections, at least the ones charged with criminal offences. Why has the Supreme Court refused to take a call? Is this the job of Parliament? Will they rise to the occasion? And what does this mean for an India that wants decriminalised politics? I've got Nalin Kohli, a lawyer and a Supreme Court advocate at that, representing the BJP here. Rajiv Gora, spokesperson of the Congress. Yogendra Yadav, founder and national president for Swaraj India Party. And of course, C. Sundaram, senior counsel of the Supreme Court. So thanks each one of you for being with us. If Yogendra Yadav is with me on the phone line, I'd like to throw the first question to him. Okay, let me just begin with Arima Sundaram in that case. And Mr. Sundaram, the Supreme Court has actively cleaned air. It has talked about forest. It has talked about clean water. But it has shied away from talking about clean politics and has in fact thrown the ball away in the Parliament's court. We will discuss whether Parliament will act or not act in just a bit. But why do you believe the Supreme Court failed to take a decisive decision on this?
Well, the answer is very simple. I won't say the Supreme Court has not taken a decision or it has not been decisive. But let's be very clear about this. This case really involves very strongly a question regarding separation of powers between the legislature and the judiciary, which is an essence of our constitution. It's a basic structure of our constitution. It's a basic structure of democracy itself. And what I can see the Supreme Court has done is it has strained at the reins to take it to the maximum extent of the border of the powers without snapping the reins and crossing that Lakshman Rekha, as you put it. The fact of the matter is, the right to stand for elections is basically a statutory right. The Constitution provides for disqualifications. The statute provides for all the manner in which a person can stand for election, who can stand, the age limits, etc., etc. Now, the Supreme Court doesn't want to add a disqualification which is not there in the Constitution, a disqualification not there in the statute. If you remember right, the last occasion the Supreme Court had to deal with it, they read in, because the Constitution provides for it, a disqualification which would otherwise have stood, which was sought to be removed by the legislature, and said you cannot do it. That disqualification shall stand because it is against the Constitution. But the Constitution itself not providing for a disqualification on the ground that a person is facing charges in a criminal offense, the Supreme Court doesn't want to add to the Constitution, which is really within the legislative province. Okay. Equally, the Representation of People's Act, which has, pursuant to the last judgment of the Supreme Court, reflected what the Constitution says, cannot also be tampered with by the Supreme Court. So what it has really done is to give all the pointers to what ought to be done to clean politics, has expressed the view that these things need to be done, but a stop short of actually legislating itself, which I think is nothing more than keeping up with the separation of powers and the basic democratic norm.
All right, let me just take this across to Yogendra Yadav, and we'll request each one of you to just keep your answers brief so that we can cover a lot of ground. Mr. Yadav, the point that Mr. Arima Sundaram makes is a relevant point, that the Supreme Court is doing nothing but it's keeping well within its rights and is looking at separation of powers extremely keenly. This is statutory, and which is why Parliament should do. Are you convinced, or are you let down, that the people with criminal charges against them can still contest elections, get elected, until, of course, they are convicted and a charge sheet is not enough for this? Has Supreme Court, in some sense, the legal arguments set aside, passed the buck to our legislators? And I will discuss whether Parliament will act or not in just a bit.
I know that many people would be disappointed with today's judgment, many who wanted democratic reforms. But on balance, I actually think Supreme Court has done the right thing for two reasons. One is a technical legal reason that Mr. Sundaram has very eloquently pointed out, and he's absolutely right. The court says, look, the law clearly says you can disqualify a candidate only for these reasons and for no other reason. And the court says, who are we then to add something to it? That's a formal reason. The court says Parliament should do it and Parliament should do it early, etc. The second is a substantive point. And I think that's something we need to talk about. Somehow, everyone is convinced that preventing the candidate from contesting election when they have charges against them is the right way to prevent criminalization of politics. I'm actually not so convinced on this count. I think what we are doing is that we are shifting the responsibility for something much deeper onto this electoral legal reform. The real problem is that our criminal justice system is very weak, very unreliable, and very time-taking. And as a result of that, many people who should be in jail are roaming out. Some of them manage to be in Parliament. And the solution for that is not that as soon as charges are framed, debar them. I think the solution is that these cases should be tried quickly. These cases should reach some kind of a conclusion very quickly. Looking for these shortcuts can give us temporary respite. But what we forget is that these shortcuts also create their own problems. The ruling party can put all kinds of cases against candidates, potential candidates. And the idea that framing of charges is a stage where judges
absolutely
discretion, that's actually not true.
No, give me a minute, Mr. Yadav, because I think you raised that important point. If I may ask the BJP and the Congress a question, that while the Supreme Court has left it to the greater wisdom of the Parliament and our elected representatives to make law, should a demarcation not have been made, say, between petty and heinous crimes? I mean, how can somebody who's charged or accused of a rape, murder, extortion, kidnapping be a part of electoral politics at all? And these are not frivolous charges which can perhaps be made. I agree with politicians on that count. Nalin Kohli, I will let you go on that first.
I think, Supriya, we are having a very good discussion because Mr. Sundaram has started by giving a legal perspective. And I think Yogendra Yadavji also is addressing an extremely relevant point. If you would permit me to take this further in a non-partisan way first, is we must also understand that criminal jurisprudence begins with the basic principle that you are innocent unless proven guilty. Now, charge sheet is a point where, based on an FIR, the prosecution says there appears to be a guilt here. At the end of the process of the trial, based on evidence and otherwise, a person may be proved innocent also, and that charge sheet may not hold true. So then the question comes that whether it is for elections or anything else, what are you going to do for the time lapse that's taken place? And you held a bar on a person without that bar necessarily should have been held. So let's take it further from what Mr. Yadav says, and I think that's something that needs to be deliberated. Basically, if you can have the dispensation of justice in a time-bound manner, certainly that's the best solution further. Maybe there may be a requirement to create maybe a statute that says that those who are in public life needs to be tried on a faster scale. But then it raises a counter question. Someone who's facing a trial of murder or rape and may not be in public life, should you really be allowing a slow process there? So I think the larger issue is to move beyond just pendency of cases, but establish a system so that dispensation of justice can be faster. And I think that's the correct approach. The second is in terms of segregation of power or separation of power, which is part of our basic structure. I think we have moved a step ahead also in this strengthening of the democratic process, because the Supreme Court is speaking about putting it out in the public domain, emphasizing that it needs to be put out in a very, very emphatic manner, and whether it's through the election commission or through the party, because at the end of the day, choice and awareness are two important parts of a citizen to exercise that vote.
Nalin Kohli. Okay, Nalin Kohli, on that informed decision making, I have specific questions. Allow me to ask a quick question to Mr. Gowda and then come back to all of you on this panel. And Mr. Gowda, okay, I agree with Mr. Yadav, I agree with Mr. Kohli that perhaps the Supreme Court has taken a reasonable stand, given that a mere charge must not bar anybody, and most politicians at large and aspirants are liable for false charges being framed against them. I agree with, the political class on this. But why can, someone not be a charge-sheeted politician not wait for his name to be cleared before contesting an election? I mean, fighting an election is not a God-given right at the end of the day.
You have to look at what kinds of cases have been filed against them, and there are cases which are related to heinous crimes, and there are cases which many people would consider politically motivated, and therefore people would not voluntarily abdicate the opportunity to contest an election. It's not the way the competitive election landscape actually works. So fundamentally, is the Supreme Court in the right by saying this is the domain of the legislature? Absolutely. And the larger principle of justice that we have all agreed to is that someone charge sheeted and not convicted should not be debarred. That is just absolutely appropriate. However, where discretion can come in is within political parties. If you know that there are charges which have been filed, and before such serious charges for such serious crimes have been filed, there is a lot of effort and some sort of collection of proof, then parties need to exercise discretion to ensure that they do not field such candidates. However, if you look at the track record in recent years, you will find, for example, that the BJP, about 31% of their MPs have faced serious criminal charges, and about 30% plus of their MLAs across the country face serious criminal charges. So it's not a question. It's not a situation where a party is taking that effort to shift. And the other, of course, the other option is for the people to reject them.
Rajiv Gaura, let me come in. Yes, absolutely. I'll come to that in just a bit. But I don't think, I don't think we can make this a partisan debate simply because you can't be pointing fingers at each other. BJP has a higher number of, people charged. So do you. I mean, it's not as if the Congress has a completely blemish-free record on that. But let me begin this round of legislative decision-making on this with the BJP because they are in power. In Nalin Kohli, the Supreme Court very clearly says Parliament must keep criminals away in quote-unquote national interest, and that the time has come for Parliament to keep criminals away by bringing a law. The question is, will they bring a law on everybody's mind today? Your government swears by providing a corruption-free, clean government, clean governance. Are you ready to bring a law like this in Parliament? Because I speak to BJP leaders off the record and they're not entirely convinced.
3 points to make. You raised a point earlier in your debate to say, why should somebody contest? I mean, it's not so important if they are facing heinous charges. The same argument could hold for anything. Why should an anchor, for example, do a show? Because that's also an important public function if there is a serious charge on them. So I think, again, you can't make this segregation for any class because end of the day, a citizen is first a citizen, then it will follow whether that citizen under Article 14, you can't distinguish and say that just because you are in a certain area of work, therefore you will be distinguished and created as a separate class. So I think you need to look at it more from a legal framework from that perspective. Second to your question, of course, that in terms of legislation is the collective will of Parliament. I think there are many things in Parliament that are still pending. I could say, for example, the triple talaq case, with intent also it's pending. It's not happened, so we are still on the ordinance route. And my learning is simple, that it remains on the collective wisdom of the Parliament when it comes to making laws. Because end of the day, it's not about the BJP, it has to be done by all parties. How can you say that something that works for the BJP in terms of an electoral reform, the other party should not? It has to be a bipartisan thing. And therefore, the issue of larger criminalization of politics, the Election Commission has been speaking of it. Perhaps the time has come for everybody to put their heads. Now, if you ask for the BJP, I'll give two counter arguments. That one of the things that our party has been saying and talking of criminalization of politics since 2009. And repeatedly we are saying that it has to be a level playing field across the political spectrum. It can't be one party's approach and not another party's approach. Everyone have to be part of that so that it's a level playing field and we all rise to the occasion of strengthening the democratic process. It can't say that the BJP will apply the bar to itself while others will not. The second is the case on black money, and third, I think, is that just as a final comment, when the Supreme Court has said so, I think we are in a good time for everyone to start putting their heads to it. Perhaps the Election Commission may lead something on it.
Okay. Okay, let me just take this across to Rajiv Gora before I go back to Yogendra Yadav and Arima Sundaram. And Rajiv Gora, do we expect legislators to get together on this? Because, you know, when it was about funding, when it was about foreign funding, it took you 30 seconds to pass that unanimously in Lok Sabha without anybody noticing it. So party lines get very blurred when it serves a politician's purpose. And which is why, because the track record of the political class has always shown that they protect their own, do we expect the Congress to take a lead along with the BJP? Will you put this government to test for bringing in a law like this? You are right in pointing out 31% of the MPs, but you also have many more in your camp who face very grave charges.
We are fully supportive of any move to eliminate criminals from Parliament and from legislatures. Let the BJP, the onus is on the government to come up with a proposal and to put a bill, bring a bill forward. We would be very happy to work with them and to push it through the committee process and ensure that a strong bill actually ensures that convicted criminals are kept out. Remember, Rahul Gandhi had torn that ordinance which would have protected convicted criminals until until all their appeals had been exhausted. Also remember that this government has, Mr. Modi had promised that he would install fast-track courts within a few months of coming to office. It has taken 4 years before such fast-track courts have even started to see the light of day. So, the promise versus the performance of this government is terrible. And it's also a government where Mr. Modi was shielding Mr. Nihal Chand, who was accused of rape, and currently Mr. Rajan Gohain, another minister, who is accused of rape. These are all people who are part of the cabinet, who are continuing to flourish. And so this government, when they say we want collective will of Parliament, bring a bill, we will support it, and we will ensure that the criminals are eliminated from Parliament.
I wish this was going to be more bipartisan in Parliament, and I wish the two of you can get together and frame that law. But give me a minute. Nalin Kohli, I'm coming back to you. Give me a minute.
I'll take less than 30 seconds. No, I'll take less than 30 seconds because it'll break the flow
of what
go
ahead.
Go
ahead, Nalin Kohli. Go ahead.
Arima Sundaram ji are going to go. So I'll just simply say, let's not forget that Mr. Rahul Gandhi is out on bail, as so is Sonia Gandhi ji. And I may remind him that Mr. Rahul Gandhi tore the ordinance and tied up with Mr. Lalu Prasad Yadav's RJD.
Okay.
So let's not break these examples.
No, that's exactly what I don't want to do. That's exactly where I don't want to take this debate. But Yogendra Yadav, I will come to you. Yogendra Yadav,
support you.
Wait 1 second. Yogendra Yadav, let me come to you. The Supreme Court in many ways has put the onus also on political parties. The court says that the political parties need to publicize in written, in electronic, print media and all of that. The two politicians on my show have said that the cleansing has to begin from within, and both of them boast of very high number of tainted elected representatives. The reality is that the onus is going to be on political parties. Can any political party comply? Because most times people who face these charges are the Bahubalis, are the people who have high winnability quotient. Sadly, that's true.
You know, there are two separate levels at which we should see the problem. Yes, criminals must be kept out of politics. I would certainly agree that the bar should be much higher for politicians than for anyone else, because they are the ones who are to legislate. So they cannot claim to be just ordinary citizens. The bar has to be much higher for them. I agree with that. And I personally sense that political parties will not do very much about it, because they would gang up as they have ganged up in the past. And I'm afraid I do not see the difference between Congress and BJP on that particular count, no matter what Mr. Gowda might say. There is no striking difference between the two parties when it comes to giving entry to criminals. And for that matter, those parties who are not present on the show, the record is not very different. But the real problem, Supriya, here is, and something we need to attend to, who is a criminal? Unfortunately, given our criminal justice system, we do not have a neat definition. The only definition is someone convicted by the court. That, of course, is already barred. What is the stage prior to that where you say, well, prima facie, this person is a criminal? Having a case instituted against you is not good enough a prima facie evidence. And the one thing we are not looking at seriously is the range of false cases this would lead to. The moment you inaugurate something like this, I can imagine within the next couple of months you would have all kinds of rape charges against various number of people who can be expected to be a candidate. How do you resolve that problem? I would again repeat that there are two fundamental problems. We don't have a solution for that, and therefore we look for this in between things which is not going to work. And the two fundamental problems is A, we cannot trust our criminal justice system to give a verdict on these cases quickly and reliably. On the other hand, we do not trust the public to simply know that someone is criminal and therefore defeat them in elections, because normally just a reputation should be enough. Why should the public wait for a court judgment? Because we are unable to do these two things in a fundamental way, therefore we look for some quick fix solution, and these quick fix solutions don't work.
Right. Right. You know, Yogesh Yadav, hold that thought, because I want to take a quick word from Arima Sundaram on this. And Mr. Sundaram, you know, very often the people with criminal records in large parts of our country, I know the court wants people to be more aware, more informed decision making. However much ever it's publicized, I come from a place like UP, and very often the people who have criminal records win because they are seen as these Robin Hood, Prince of Thieves, these Bahubalis, these strong armed men. And so the question really is this going to help at all? You know, leaving it to the parties and leaving it to the candidates to make full disclosures. Because gone are the times when people would quit public life and politics or you know, quit from their positions because a charge was leveled against them.
Supriya, actually you put your finger on it finally. Let me tell you that for me the greatest takeaway of this judgment is the fact that this requirement to publicize your criminal antecedents or to publicize the fact that charges are pending against you. The reason for this, just look at the reasoning. It makes a lot of sense in one way. What is the fundamental trait of a democracy? A democracy is people choose their leaders, people choose their government, people choose who they want to govern them. Now, if all the people in an area want a person who's charged with crimes to represent them, well, that's his democratic right to choose. So what has the Supreme Court done? And that's the big takeaway. They say, all right, let him choose, but with the full knowledge, fully informed as to whom he is choosing. If after that he still decides to choose that person for whatever reason, and you say, no, you cannot do so, aren't we going to a basic jurisprudential thing about, are we going against democracy? Now, disqualification for being convicted is one thing, but to say that a person who has been charged cannot stand for elections and people cannot vote for him, although all the people want to vote for him, does that not go against democracy? Therefore, the problem lies deeper. It lies in our electorate. Our electorate does not feel that the fact that a person is facing charges is a ground not to vote for him, not to have him as a leader. Right. And that is the big takeaway of the judgment. The court says, all right, if that's what the electorate wants, that's a democracy. But let's be sure that the electorate knows. Let's be sure that the electorate is voting for that man with open eyes, which is why the publicizing factor. And if after publicized, and if the electorate knows that this man has criminal charges and still wants him, well, a democracy, what's the cardinal rule? You get the leader you want, or you get the leader you deserve.
You get the leader you choose, yes. Okay. On that note, I think all of you have kept this debate civil. I really think that our political class needs to get its head together, wrap their heads around this one and find a way out. We cannot in the 21st century talk about decriminalization of politics. We should have had it by now. In any case, given our politicized investigation, opaque laws, slow justice, who gets charged, who gets convicted depends a lot on the party in power many times, and that is unfortunate. But at least the Supreme Court has begun the discourse, the discussion on cleaning up politics. We hope we will get to Swachh politics in this country beyond everything else. Thank you very, very much, Mr. Arima Sundaram, Yogendra Yadav, Nalan Kohli and Rajiv Gora for joining us on this edition of the India Development Debate.